Hi everyone, this is Hina Belitz from Partners Employment Lawyers. Today I'm going to talk to you about the 4 biggest problems that arise in contracts of employment. And I think these are so important that I've actually chosen not to refer to several others that are quite important, just to emphasize the importance of these 4. Now, the 4 items that you need to be wary of are, number 1, the payment in lieu of notice clause. Not only is it fundamental in terms of its ability to protect key clauses like confidentiality and post-termination restrictions, because if you do not properly deal with a termination and the issues around post-termination payments in lieu of notice, then you can in fact end up breaching the contract, and that can lead to huge problems. Added to this, there's some recent case law which has highlighted that the way we believe payment in lieu of notice clauses operate may not be the way they are operating because of a drafting issue. They are often drafted to refer to termination taking place on payment of money in lieu of notice as opposed to notification. We have the correct clauses, so if you need to address this, just contact us and we will let you have the details that you need. The second point of my 4 are social media clauses. More and more we find ourselves at court and tribunal having to address issues like someone continuing to represent themselves as connected to the company on LinkedIn, or comments which disparage the company being made through Facebook. There are so many relaxed attitudes taking place around social media. People don't appreciate that it is actually publishing, and there is almost a veil of ignorance around social media, and people don't realise effectively that what they are saying is in the public domain and will be seen widely. And so we have devised a series of very critical and important revisions to the standard contract and handbook to deal with social media issues. And again, if you would like to know what they are, feel free to contact us and we can assist you on that. The third point is in relation to changing contractual terms. There is a process, a legal way in which you can lawfully change terms and conditions of employment, even against the will of staff that you employ. So that's a very, very useful and powerful thing to be able to do in itself. However, there has been a recent case which has highlighted a clause which is effective as a contractual clause for changing terms and conditions of employment. Now, don't get confused. I don't actually ever recommend relying on a contractual clause. However, if you do know that you might need to make a minor change and you have someone who's problematic, it's better to have very good drafting and a clear clause in your contract so that you can attempt to rely upon that alongside any other methods that you might use. So that, again, if you need details of that, contact us and we'll let you have details. And finally, garden leave. I think that a lot of garden leave clauses are not drafted as effectively as they can be, and there are a few additional revisions that we've included in ours, which mean that you can actually take and have better control over staff if you're releasing them and placing them on garden leave. Now, the thing that I think you have to be careful about with garden leave is that it is actually a lot more powerful as a means of protecting activity after someone leaves than a post-termination restriction is. Yes, it does cost because you're placing people on paid notice, paid leave. However, that bearing in mind the protective effect that a garden leave clause can have, I think it's well worth making sure that you redraft, including the revisions we suggest, so that they are as powerful as they can be. Thank you very much.